welcome everyone to our ninth and second to last video in our advanced video series for Consumer Law 101 Consumer Individual course. Again, I'm your course instructor, Attorney Aaron Swift. I'm the Swift Law North LLC's CEO and managing partner. As always, we start with an agenda, and again, today's video is the secrets of the debt collection industry. So the agenda is secrets about the underlying money, secret collection strategies, and then finally, secrets consumers can use to fight back. That'll also be some of our best practices. All right, so let's talk about secrets of the underlying money. So, per ProPublica, debt collectors made over $3 billion in 2010. So, first of all, that was almost a decade and a half ago. And that's just the money they generated. That's not the money they collected. So that's on top of whatever amount they collected for their clients, their principals acting as their agents. They were able to make on top of that $3 billion themselves. So just put into context how much money they must be collecting for their clients if then they're paid $3 billion. Um, one of the secrets is most debt collectors get paid a certain percentage of the debt amount saved. um, it really kind of aligns an incentive to get as much as money as possible. So, if they go in and they're collecting between a certain range, they get bonuses and they get paid a percentage of the debt that they collect. And that really incentivizes them to collect a lot. And then again, if they have other certain metrics about you can settle between certain ranges, then they get paid even a percentage of that additional debt amount saved. So individual debt collectors are also paid by incentives a lot. They get bonuses, commissions, based on certain amount of debt they save with certain ranges. And also they get paid the more money they collect. They want to be good at their jobs. You can imagine a review for a debt collector in terms of an HR review is going to be how much money did you collect? The first and primary answer. It's not going to be were you nice. So it's why some of the individual debt collectors take it so personally because they're personally invested. Their livelihoods are, and it really does. I used this term in a previous video. Kind of creates a race to the bottom where you're doing just enough to skirt the line of breaking the law to collect the most money because you're incentivized to do so. So, generally, debt collectors are always going to start out trying to get 100% of the debt, but virtually all debt collectors have authority to reduce the debt by some percentage. Now, I say debt collectors very importantly there because I'm talking about the true nature of the term. Go back to our videos, we've talked about parties in the FDCPA. We're talking about third party debt collectors or talking about debt buyers who qualify as debt collectors. They are often willing to take a certain percentage off of the debt when negotiating. First party creditors are a lot more difficult, especially credit unions. It's not always the case that they're willing to settle debts for anything more than 100 or less than 100%. Sometimes they'll agree to 100% over a payment plan, but it's much easier with debt collectors, third party collectors, collection, trade line owners, current creditors that were not the original creditor, debt buyers, junk debt buyers. And most of them have authority to reduce something in terms of a settlement. Um, and then, interestingly enough, in 2019, 5 years ago, debt collectors collectively paid tens of millions of dollars to the big three to credit report debts and collections. So think about that. In 1 year alone, debt collectors collectively, they made over $3 billion of revenue. So they've got a lot of money to spend. That was, 14 years ago. But then collectively, just paying for the privilege of putting negative collection trade lines accounts on consumers' credit reports, they paid the big three tens of millions of dollars. And ironically, or maybe not ironically, but one of the secrets about this industry is that's how a lot of the big three make their money, by selling reports on one end, by having these other types of products like employment products or medical products, but they get paid fees by their subscribers. They call the furnishers subscribers. They subscribe to this system that they're allowed and have the privilege of then, putting information into and furnishing information into. That's again trafficking in our personal lives, but they pay for that privilege. They pay handsomely for that privilege. So the big three and other credit reporting agencies, they make a lot of money by subscriber fees because you have to subscribe as a furnisher. It's why some smaller debt collectors don't report to all three. It's expensive. It's also, when you think about it, a reason why these parties often agree with each other in scenarios where there are disputes, because they're aligned. They have a financial incentive to be aligned, and so often the consumer is the one that's victimized, because if a debt collector is already paying tens of million dollars to the big three, and now there's a dispute about how should a debt collection trade line be reported, you wouldn't be shocked to know that the big three and the industry furnishers are often aligned and against the consumer. So, all right, let's talk about some secret debt collection strategies. They're not stupid. Debt collectors know that a lot of people get paid on the 15th and the end of the month or the first of the month. So that's a lot of times where they try to target the receipt of their letters, their phone calls, their text messages, emails. They will often target those times. Remember, going back to some of the protections that we've learned about, if there's a successful call from a debt collector during those times, they have to wait a certain period of time, a week. So think about that if you do get a call, now that you know that you're more likely to get a call during those periods of time. Another interesting thing is that debt collectors love to target tax time. They love the beginning of the year when consumers start filing their taxes. They love the first couple months when tax returns start to be, deposited into consumers' credit accounts, or excuse me, checking accounts. That is the best and most profitable season for debt collectors. In fact, they use a lot of even language about, hey, this is the perfect time. You may not be able to afford us during your regular bi-monthly or weekly paychecks. We get that, but now you have some extra money around from the federal government. Why not use it to settle with us? We're really swell guys, because we'll take a percentage off, as long as you use these funds that you might have set aside for something else. But no, use them to pay us, use them to pay debt. So um, another thing is, remember, debt collectors can permissibly check credit reports. That's something that's entirely misunderstood. A lot of misrepresentations and lies told in the credit space, credit repair space, that debt collectors can't credit report. They're not allowed to. They didn't, no one gave them consent to, or they're not allowed to check credit reports. It's all nonsense. They're certainly allowed to check credit reports. They're allowed to credit report, under the proper circumstances for all the above. But because of that, they know a lot about you. Debt collectors might play dumb, but they know a lot. They know basically a range of income. They know your job history. They know what other debts you are paying and you're not paying. So they can roughly even try to guess what your disposable income is every month. That's before you even ever connect with them. And that's based on the information they're able to collect publicly, and then through their ability to check credit reports. So um, another debt collection strategy that we hear about a lot is pay for deletion. Technically, they're not supposed to do this. If a consumer pays for a legitimate account that's in collections, the debt collector is not supposed to agree to delete it just as consideration in exchange for the payment. Because what that does, it violates their subscriber agreements, the agreements I talked about previously, how they make so much money from, that says you have to report accurately. And it wouldn't be accurate to say this is a true debt owed and accurate until they pay it. There's a way to then report a collections as paid. And that's what the bureaus and the credit reporting agencies would say. And probably the law would even say is technically accurate. So they will often agree for pay for deletion. And sometimes it's proper to, and maybe a lot of cases, because there may be a payment or a settlement, and that settlement has a reduced amount, and there's not an agreement that the debt's owed. There might be some legitimate dispute. So, as consideration for a payment that's reduced, you could agree to delete something that you may not be sure could be verified as true. And that would be an instance where paying for deletion would be proper, but just the general practice is not up to industry standards. Um, the collectors can and will call third-party references to locate you. It's something they're allowed to do once. They cannot disclose personal information. They cannot talk about the debt, or even that they're debt collectors. They can only talk about there's a personal matter and they're trying to locate you. And if that third party says, "Don't contact me anymore, I don't know where the consumer is," they have to stop. But that is a secret that they will use, and a lot of people don't understand that that's legal and can be proper. Debt collectors use text messages a lot more frequently now. They use social media messages, drop voicemails, which are really nasty in my opinion. That's where your phone never rings and all of a sudden a voicemail pops up. And if you're like me and a little OCD, I don't like having unread voicemails, or unlistened to voicemails, I guess is the proper term. So if one is just dropped there, I wouldn't even have known that I wouldn't have rejected that call necessarily. I like to listen to my voicemail, so that's a trick. That's particularly nasty. And now a lot of AI is being used. AI is being used to try to determine the best strategies, the best timing, how much money to ask consumers for. It's also being used to impersonate humans, to interact with consumers with really sophisticated decision trees. That just means we're going to have to fight back a lot more. And then there's use of the new technologies that can often lead to abuses. So we're going to be looking for violations. The other thing too is debt collectors, again, they make a lot of money. Remember, billions of dollars. So they are smart. They're very well funded. They employ expert psychologists that write their SOPs and manuals on the best tactics to use. They have sales staff that take really aggressive training that basically sell you on paying them money in a way. They kind of consider their collectors as salesmen or salespersons. And then they even expert negotiators to kind of help train their staff. So it's all to beat down the collective will of consumers in a way that, again, is kind of particularly nasty when you consider a lot of consumers in these positions are there because of a job loss, a medical event, a family event, situations outside control, but they're trying to, nonetheless maximize their profits. And the way they do that is with, these secret strategies. So what can consumers do to fight back? What are our best practices? So some of those consumers, or secrets are just knowing the basics of these laws. And I would consider them secrets because so few consumers even know they exist, let alone that they have power, and let alone that that power can be used without having to pay attorney's fees and costs. So much of the consumer fear in this space is because if I'm fighting over a small little debt that's not a lot of money, or it's an account on my credit report, how am I ever going to afford a lawyer to do that? Well, now with watching our videos and hopefully taking good notes and just picking up on a lot of the trends here is that if we find violations of these laws, if we're able to use these best practices to fight back, we do so on a contingency fee basis. That means, we don't get paid unless we win. So, we have better tools for you. We have pro videos 1 and 2 for the next video series coming up that have directions on these processes. We also have our templates in the next video series available to you that are lawyer drafted, that come from a very good fresh start, at least not complete, fresh slate, but a good start that is devoid of any other nonsense. And I say fresh because it's better than some of the flashy things or other tools you may have hopefully not purchased or at least been misled about in the past. But if we're able to use these tools successfully, these best practices, we want you to reach out because you're going to know when they violate the law. And if there's violations of the law, it could be damages, it could be deletions from credit reporting. And again, no fees or costs out of pocket, the bad guys pay. So for more educational content, especially because we're getting to the last part of the advanced video series, check out consumerlaw101.com for more information about the Pro Series. There's also more content there for businesses, credit professionals, and the content's only going to grow from there. Lastly, if you think you've been violated or harassed by debt collectors, credit reporting agencies, any actor in this space, and you've been suffering damages because of it, reach out to us at swiftlaw.north.com. We'd love to help. Thank you.